You're watching The Legal Breakdown. So Glenn, we've got a pretty big update here that may have major implications for Donald Trump's Florida prosecution. A judge who was appointed by Trump himself refused Hunter Biden's effort to use the Trump ruling in Florida to get his own federal tax case dismissed. That was the one that he was indicted for. So clearly, the Judge Cannon precedent isn't having much sway. Does this suggest that maybe the lawfulness of Judge Cannon's order is in doubt?
Yeah, it does seem like federal court judges, one after another, are in substance lining up against Judge Cannon. Her ruling that, special counsel, just not a thing. It's not lawful. It's not constitutional, all of which, based on the law, is nonsense. But, Judge Cannon, in her determination to do a favor for Donald Trump, decided to be the outlier as a federal court judge and throw Donald Trump's case out. Well, Hunter Biden is charged with tax crimes in federal court in California, and the judge presiding in that case is Mark Scarsi. He's a Trump-appointed judge, Brian, as you pointed out. Interesting fact about Judge Scarsi, he joined the Federalist Society in 2017, and Donald Trump appointed him to the federal bench in 2018. But notwithstanding that, Hunter Biden's lawyers, when they saw Judge Cannon say special counsel's not lawful, and remember, Justice Clarence Thomas, Supreme Court Justice, authored that little love note to Donald Trump and CC'd it to Judge Cannon, saying in his separate concurring opinion, I don't think special counsel is lawful either. And of course, Judge Cannon picked it up and ran with it and dismissed Donald Trump's classified documents, obstruction of justice, espionage case down in Florida. Well, Hunter Biden's lawyers, when they saw that, said, us too, Judge Scarsi, we want to now say that special counsel, and of course it was a special counsel who prosecuted Hunter Biden, special counsel's not lawful. And Judge Scarsi really lining up with all of the other federal judges in federal courts who have had to decide this issue, said, no, motion to dismiss, denied. And here is just one line from Judge Scarsi's opinion. He says that there is no valid basis for reconsideration of his decision not to throw out Hunter Biden's conviction based on the special counsel attack. There is no valid basis for reconsideration, and neither Justice Clarence Thomas's opinion nor Judge Cannon's order is binding precedent. A pretty loud and clear signal that Judge Scarsi said, yeah, I don't have the time of day for what Judge Cannon was claiming and then using as a vehicle to throw out Donald Trump's case.
Let me ask you this. If there was a stronger legal basis for this Cannon ruling, is it possible that a trial judge could invoke it, even though it's not officially precedent until a circuit court actually upholds it?
Oh, absolutely. So, what one federal court judge does is not precedent to another federal court trial judge. However, it can be very persuasive. In fact, we call it persuasive authority when there is some other ruling out there that applies to the facts in your case. But so Judge Scarsi certainly wasn't bound to apply Judge Cannon's reasoning and rationale and reach the same conclusion, nor was he bound to apply Justice Clarence Thomas's concurring opinion in the absolute immunity case, saying special counsel ain't a thing. But it would be pretty persuasive to most federal court judges if it was in accordance with the damn law, which it is not. And that's why Judge Scarsi exercised his independence, did the right thing based on the facts and the law, and refused to throw out Hunter Biden's conviction.
Well, all of this raises the question, because now we're waiting on the circuit court to actually make this precedent or knock it down as possible precedent. So when will the 11th Circuit Court actually hear this appeal?
Yeah, it's a great question, Brian. We have been waiting. So as of right now, I don't believe the 11th Circuit Court of Appeals, which is the appellate court that oversees and takes the appeals from the Florida federal court judges like Judge Cannon, I don't think they have yet set an argument date. So it could be set in a matter of, the next couple of days or weeks, and then we will know precisely what date they will hear oral argument in that case. It could easily be before the presidential election, but I don't think it necessarily will be. But even after it gets argued in the 11th Circuit, Brian, it will probably take the judges some time to resolve it. So I wouldn't look for that opinion in necessarily the coming weeks, but we could see it within the next few months.
Glenn, Donald Trump keeps saying that he won the Florida case. What's your reaction to that?
He didn't win the Florida case because the Florida case was not tried on the merits, on the facts, on the evidence. It was thrown out on what I'm going to call a legal technicality. And the thing is, Brian, Judge Cannon was dead wrong on the legal technicality. So basically, Donald Trump succeeded in getting a biased judge whose impartiality absolutely can be questioned, a judge he appointed. She owes her lifetime job in that black robe up on that high bench to Donald Trump, the very defendant in whose case she is presiding. She threw it out. She had no right or reason or legal authority to do it. So that is not winning the case. It is a temporary setback for justice that I'm convinced will be remedied by the appeals court.
And let's finish off with this, because I know this is the question that most people have. How likely is it that if and when it does get sent back to the trial court, because it's knocked down by the 11th Circuit, that Judge Cannon won't be the same judge to oversee this whole case again?
Brian, I have to say, I think there's a strong likelihood, given Judge Cannon's track record of abusing her judicial discretion in favor of defendant Trump. I think there's a strong likelihood that the 11th Circuit Court of Appeals, which oversees that federal district down in Florida, will say, you know what, we are returning this case with direction that it be reassigned to another judge. I've seen federal appeals courts do that in other cases, in other jurisdictions, when they had a significant question about the impartiality and the judgment who got it so terribly wrong, like Aileen Cannon continues to get it so terribly wrong.
And I have to ask this, because we've seen over and over how Jack Smith is hesitant to request this. And I got to ask this because we've seen how Jack Smith is so hesitant to actually request a motion to recuse from Judge Cannon. So does he have to request that motion from the 11th Circuit, or can the court just decide to do it sua sponte, unto themselves?
Courts can do things sua sponte, in other words, on their own, without even being asked by any lawyer, any prosecutor, any defense attorney. However, Brian, I think courts, judges have a comfort level when there is a request by, for example, a prosecutor to remove a judge because their impartiality might reasonably be questioned. That's the language of the federal law requiring a judge to remove themselves from a case. I think there's a comfort level that comes along with a prosecutor making the request, briefing it up with all of the supporting authority and all of the facts, the evidence that lead the prosecutors to that conclusion. But judges can do it on their own, and I have seen judges act sua sponte on their own when they think it has to be done in the interest of justice.
Well, it does have to be done in the interest of justice. So, of course, you and I will stay on top of this as this prosecution and the appeals process continue to play itself out. For those watching right now, if you want to follow along, please make sure to subscribe. The links to both of our channels are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.